friends. This is Soumitra Lahiri, author of Guide to IBC. I'm sorry, my features have been changing. Earlier, the hair is a little bit grown. It was completely, uh, I was becoming bald because due to, and my mother passed away because of the shard and things. I've broken my arm also. Times I do pass. But one thing is good is a day is limited to 24 hours, and a month is limited to 30 days, a year is limited to 365 days. So that time is also do pass over. Now, what I would like to tell all my viewers is that guide to IBC.com is a huge website. If you try to go through all the judgments in one go, so what is most important is you should know how to navigate the website and how to keep in touch. How to keep in touch with developments which are taking place. The approach of the court is changing from time to time. Law is getting amended. And it's not that law gets amended once or twice in a year. The court's approach changes. So and what you see in the way of amendment is the approach of the court. So today we are basically going to discuss a very few cases because last week was a very small week. We had Good Friday in between, and so the court was hardly open. But I'm going to start with one particular case, which is not a case of last week, but it's immensely important. I feel that one should know. So I'm going to go to your screen and share with you guys. You see, now you can see guys. Now, one of my clients from asked me, had told me that they had a inherent trust. And if CIRP they could be brought under the realm of insolvency and bankruptcy code. Well, I had hinted anyway. But I found that there are judgments. If we go to section 2, instead of doing this, let's go to section 2. In section 2, I looked in and I found that I have in topic 7, the word person is defined as per section 323D, IB Code 2016, which includes a trust. Therefore, there is no fetter or embargo or a legal impediment for a trust to be a resolution. To a trust, then there are a number of cases. Supreme Court M.K. Rajagopalan versus Dr. Periyasamy founder. Then Mrs. Avasti Agency versus Vijay Prabhakaran Pulipra and G. Balasubramanian and another versus CN. So it is known that trust can be resolution applied. But there is a hypothesis, there is a little bit of confusion remaining as to whether whether for CIRP trust can be put under CIRP. Now, in order to become under CIRP, what is most important that it has to be considered as a body corporate, or rather to says what? Such others, these is such other body incorporated that any law for the time being enforced, and the central government thereby would specify in this way. So, or B says any other company governed by any special act for the time being enforced. So, in order for trust to become, we have to find out, because trust is definitely it cannot come under individual. searched a lot, and ultimately I came to a judgment of Messrs. Abraham Memorial Educational Trust versus C. Suresh Babu from Madras High Court. This is a 2012. This is a beautiful judgment, a huge, which says that when a person is ordered, understood to be a natural person, it only means a human being. But this human being, being a person, is also an advent of development of humanity. Earlier, slaves were not considered to be persons. So, the, that a person is also artificially created, recognized in law. As such persons are by different names, such as juristic person, judicial person, legal entity, etc. The beautiful headline in this is perhaps the oldest and of all juristic persons is the god, hero, or the saint. So God is also, we find in India, deities are there. In divine deities who have wealth, who are earning out of it, and they are taxable also. They may be taxable. So even a charitable trust, in order to exist, they have to earn profit. If not, profit can be by way of information. But then it is an income. So we cannot say, even if a trust definitely has something, and it is created by Trust Act. So in this particular judgment, it held that trust can issue checks, trust can hold properties, trust if it defaults, then it comes under a negotiable under section 138 of negotiable instrument. The public trust is capable of contracting, it's capable of making checks, bill exchange, and so it is a juristic person for the purpose of the same act. Right to own property has been given to all persons, including a public trust as well. So under the Transfer of Property Act, right to transfer such property, the public trust has recognized. So ultimately, the court came to an opinion: trust having two or more persons will fall in the ambit of association of individuals, and thus such a trust is a company. But a trust having a single trustee will fall within the ambit of association of individuals. So that means this is the lone judgment which I could come up with, which I could find out. So that means going by this judgment, trust can definitely be brought under CIRP. And maybe some of my readers may be lawyers, some of them may be insolvency professionals, some may be trust ownership. So take care. You should know that trust can be brought by insolvency. If you can become a resolution applicant, you can might as well face insolvency as well. Let us go to another case. Now, let us go serially. So let us go to section 7, not section 7. Let us go to section 10. 10A, and possibly let us go to regulation proceeding. No, 10A 12. So sorry. So this is a lateral shift which took place. Topic number 8. This was possibly one of the last judgment of our ex-Chief Justice, Dr. D.Y. Chandrachud, in Glass Trust case. He mentioned that once an application has been admitted, the proceedings are no longer the sole reserve of the applicant and the creditor and the corporate debt. They are now REM. They are now in REM. And at this stage, the NCLT must hear the concerned parties and consider all relevant. So there is a lateral shift. Earlier, we had, if the COC is not formed, you can go ahead and file it to withdraw. If COC was, I mean, therein whether the claim was accepted or not, this was not taken into. But in gas trust, this ideology completely changed. But gas trust company LLC versus Banji. This was in 2000. This was civil appeal number 9986 of 2024. And recently, what judgment we have is Riju Ravindran versus Pankaj Srivastava, company appeal, Chennai. This was also by BCCI. So, in which the court said that the Form FA was filed formation of COC. So, here BCCI had asked the RP to apply for withdrawal. But the RP, since the matter was held up in Supreme Court, RP declined, said that the matter let it be first decided by Supreme Court and then we'll. And he had taken up, he had accepted the claim. So there was a creditor who was holding 99.41% stake. So Enclad said that Form FA was admitted after having been filed on 14/11/24 is post COC. If the application is filed after institution of COC, the provisions of Section 12 will apply in full force. So that means the plea of COC having no peak form was not accepted. Now, let us go to, there are some important judgments. There is one judgment in, let us go to Section 237. So let us first do a individual and firm, Section 95. This you must be aware. Still then, this is a individual and firm being a new thing. It's better when a new case comes up, it's better to discuss. Topic 32. The existence of a corporate insolvency resolution process, CIRP, against the corporate debtor has not or does not include the initiation of or continuation of proceedings against the personal liability. So this was a case between Ram Kishore Arora. Yeah. Ram Kishore Arora versus I. The last case, in which the court opined that personal insolvency proceedings are not dependent on the proceedings under Section 7, which are proceedings against the corporate debtor. The liability of the personal guarantor and the CD to the lenders are coextensive, and it is open for the lenders to proceed against both simultaneously or separately. Insofar as the admission of application under Section 95 that cannot be faulted on the ground of pendency of proceedings under Section 7 against CD. So Section 7 was not completed. And the party had come and said that they were trying to settle it. So the court opined that it is open for the appellant to bring before the RP settlement with IFCI Bank, if any, or any proceedings that, or any settlement which is entered into the proceedings under Section 7, which is pending consideration for Honorable Supreme Court. So you settle. If the settlement is done, bank gives a no objection certificate, gives a no due certificate, the case is not there. But so long that does not take place, it is very much there. So let us now, as I say, that this is going to be a very short discussion. So let us go to. In 237, we didn't have any case. 237 is appeal and revision. The High Court may exercise so far may be applicable. All the powers conferred under Chapter X 29 and P of the Code of Criminal Procedure 1973 on a High Court as if a special court within the local limits of the jurisdiction, or a court of session trying cases within the local limits of the jurisdiction of the High Court. Anyway, we are, instead of going into the definition of that, let us look into the case. Okay, the topic is inherent jurisdiction may be exercised by High Court to give effect to the order, to an order under CIRPC, to prevent abuse of the process of court, three, to secure ends of justice. This is a case of Qureshi Singhal and others versus State of Gujarat and others, Criminal Appeal 3862 2024. Now, here in this respect, let me tell you that it is not necessary that I stick to insolvency bankruptcy. If I see a case which may have a bearing on insolvency bankruptcy, this is to do with PRT. But what I felt that this is applicable to insolvency bankruptcy court also, or to a CD who may be having a settlement or something, or settlement, and there is a case. It appears that CBI had moved against the corporate, against the promoter or corporate, and the corporate matter there was a DRP proceedings. They had settled things with Bank. Bank of Maharashtra had given them the no due certificate, had taken them out of the defaulters list, and had put them back in the civil ladder also. But CBI continued the proceedings. The Supreme Court said that the dispute is primarily civil nature. The aggrieved party, if any, would have been the bank, which has no grievance against the appellants. So why are you bothered? If the bank is if any party would have been aggrieved, it would have been the bank, not you. Continuation of these criminal proceedings would put appellants into great oppression and prejudice. Extreme injustice would be caused to them by not watching the criminal proceedings. In cases where charge is framed, but the evidence is not yet started or is in a very infancy state, the High Court may exercise its power by showing benevolence after a prima facie assessment of the circumstances and material mention. As I said, this is not an insolvency case. This can definitely have certain amount of implications. Let us go to 238A. We have two cases in 238A, which I would like to bring to your notice. Yes. 60. Once Section 7 application is filed, the date of default in Part 4 becomes filed. The case is Deepak Mahadev Shirke versus Unity Small Finance Company Appeal, so and so. In this case, what had happened was the NPA was declared sometime in 2019, and in between, DRT had issued a decree also. Now, a final judgment or decree of any court or tribunal, many arbitral award for payment of money, if not satisfied, would fall within the ambit of financial enabling the creditor to initiate proceedings in the So here in this case, the date of NPA was 2012 to 2009. Now, the date of default mentioned in the Section 7 application shows that the date of default of the corporate appeal and respondent is 12/11/2018. So the court mentioned from Asset Reconstruction Company Limited, Asset Reconstruction Company India Limited, that's RSIL, versus Vishal Jaiswal, 2021, 6 SCC 36, that's the Supreme Court. It is clear that Honorable Supreme Court did not allow the date of default to be amended merely on the basis of oral arguments. So once Section 7 application is filed, the date of default becomes binding. The adjudicating authority could not have held, and the arbitral award of 28/2021 had reached the limitation period. I'm sorry, it was not DRT, it was arbitration. The arbitration award had the adjudicating authority has erred in extending the period of limitation on the basis of. Of course, the party here was given liberty to file Section 7 again by changing the date. But once Section 7 is filed and you mention a date of default, well, maybe you have an arbitral award, but that won't change anything. The date of default has to be changed. If you don't, then as far as Vishal Jaiswal's judgment, you cannot, the Section 7 petition cannot be considered. It's also one judgment, 63. There is a rational limit till when the restoration of CIRP petition can be. Now you have filed a CIRP and you have the party has come to a settlement, you have settled the debt, you have withdrawn. The court has given you a right to restore in case the settlement terms are not adhered. But in this particular case, ET Chemicals versus Indo Laminates quoted that the CIRP having been closed in 7/6/2019, when the application for revival filed 5 years. After 5 years, it was noted that people have filed the application after 5 years closure of seeking a revival. In the event of settlement was not honored by the corporate, it was open for corporation to immediately come to the court. Revival after 5 years has rightly been refused. So your right to revive the petition is also limited to the extent there is a rational limit to which you can ask for a restoration of the petition. I think I'll stick to this only this week. I won't go much. There have been number of cases. It will take a lot of time. Let us stick to this. In the next in this week, hopefully we'll have a lot of judgments. I can take some of the judgments of last week also. And in any case, as I say, as I request my viewers, I implore to my viewers, please check the front page, the home page, in which the new cases are. Every day you will see the cases scrolling up and down. You click on them, you see the section and the topic. You go to the topic, section and topic, go to the topic and see what the case is about. And once you do that, it's not, my mind is not so high-tech a site. So from here, you cannot straight away jump. So you'll have to navigate. So once you navigate, you will get to know where how to navigate the entire right to IBC. And once you do it on holidays, you can go through section wise, you can see the topic. But this way you stay abreast with the latest W. Thank you for patiently hearing me. And thank you as I see that the visits to Guide to IBC is increasing. It is becoming popular. I'm so thankful to all my readers. And as I said, my children are not interested. They're not in my profession. I'm also aging. I'm looking for somebody who is going to take this Guide to IBC and take it forward. And thank you